please.
Hi, everyone. I'm Jessica Waldron. I am the Designated Examiner Regional Program Specialist for the East Hub in the Division of Behavioral Health for the Department of Health and Welfare. I've been working in the field of mental health since about 2001. I got my master's degree in 2002, and I have been with the department since 2011. So, Dia, go ahead and.
Thank you. I'm Dia Hibden, and I'm the program specialist for the 18-12, 11-12 in Northern Idaho, which is basically wherever we're in Pacific Standard Time, that is Northern Idaho. And I have been with the department for 20 years and have been working on competency and restoration for probably the last 11 years was the first time I had an individual that needed to go through the restoration process.
Great. Well, let's get started. So just to review the learning objectives that by the end of our presentation, you'll hope to have a basic understanding of the competency law and process here in the state of Idaho, understand how to access and navigate the Idaho Statute, Title 18, Chapter 2, understand the competency criteria, the evaluation process, and the potential outcomes for that, understanding the competency restoration process, and then the legal timeframes for the competency and restoration process. So if at any point in time during the training, if you have a question or a comment or something, please feel free to either use the reaction, raise your hand button, or we'll try to monitor the chat as well so that we can answer things along the way. But we'll also have some time at the end that we can review questions as well. So quick history on where the competency process has kind of developed. So essentially, the insanity defense was developed in England in 1843, and it's evolved quite a bit over the years. They have had legal codes as far back even in ancient Rome that distinguished between what they used to refer to as lunatics, or those that were considered not sane or responsible for their actions. So the shift over the last 2 decades in across the world, but primarily in the United States, things have shifted significantly, especially the incident where John Hinckley attempted to assassinate President Ronald Reagan, which occurred on March 30th, 1981. He ended up prior to the assassination, he had a diagnosis of schizophrenia. He had been treated and been living in the community. He became obsessed with the book and the movie The Taxi Driver, which in that film, I actually haven't seen the film, but in the film, the main character is a taxi driver who becomes kind of obsessed with a woman who works for a presidential candidate who's running for president. And he began to become so enthralled in that movie that he began to kind of take on the persona of that character and believe himself to essentially be to be the individual in the movie who happened to be in love with Jodie Foster. So he wrote a lot of letters, sent a lot of messages and things to Jodie, and his attempt to get her attention, he ended up he was at the Washington Hilton when President Reagan was giving a speech there. And as President Reagan walked out, he yelled to him, and then he fired 6 shots and hit the president and 3 other individuals. Luckily, all of them survived, although a couple of them were permanently disabled from their injuries. So due to all of the evidence that was presented at the trial, he was found not guilty by reason of insanity, which there was a lot of backlash across the country after that happened. In fact, the ABC News took a poll the day after the verdict, and 83% of the people polled felt that justice had not been done because of him being acquitted. He did get committed to I think it was called St. Elizabeth's. Check my notes before. Yeah, St. Elizabeth Hospital in DC. But he was eventually released from there in 2016. So essentially, the 3 years after he was acquitted by reason of insanity, almost every state in the nation made some sort of alteration or change in their competency and insanity laws. And in Idaho, they made their change pretty quickly. So in 1982, they enacted the code 18207, which made the use of mental condition shall not be a defense to any charge of criminal conduct. So essentially, they made it against the law to use the insanity defense. And we, as of today, we are one of only 4 states in the nation that do not allow for the insanity defense. Kansas, Montana, and Utah are also have also eliminated the insanity defense. Let me switch the slide to the next one.
Now we're going to try there.
Okay, so this is the link to the statute. This one is a little bit trickier to find if you're not familiar with how to access the statutes. It's in Title 18, which Title 18 is titled Crimes and Punishments. And then Chapter 2 is persons liable, principals and accessories. So it's identifying who can be charged with a crime. And so in that chapter is what covers a person's right to be a competency evaluation and restoration process. Okay, so one big court case that has had an impact specifically on competency is the Dusky versus the United States, which was in 1960. Milton Dusky was a 33-year-old at the time of his arrest who had a prior diagnosis of schizophrenia. He was a Navy veteran and was living in the state of Kansas, and he was married and I believe did have just one teenage boy. So in March of 1958, he was in the hospital for one of his numerous hospitalizations. And while he was in the hospital, his wife divorced him and ended up actually marrying his brother years later. But that kind of set off a downward spiral for him. He'd also had a long history of alcoholism, but the alcoholism took on a life of its own, essentially, after he got out of the hospital at that point. Once he got out of the hospital, he was renting a room from a woman who his son, who was staying with him at the time, had some friends over, left the door open. The dog got out and got hit by a car. So the woman who was renting him the room kicked them out. So he essentially at that point in time, then it was homeless and sleeping in his car. So on the night of August 18th, 1958, he picked up his son and a couple of his son's friends. I think they were 14 and 16 years old at the time. And they went into a neighboring town. So he lived in Kansas, but they went to a neighboring town kind of outside of Kansas City, Missouri. So they were in a different state as well. And they went to a drive-in movie theater there, and he drank a couple of pints of vodka, took some tranquilizers. They ended up encountering a 15-year-old girl who was walking that the two teenage boys knew, and they had offered her a ride to the neighborhood drugstore, something. She was meeting a friend for lunch, and they actually did take her to the drugstore. And then after a while, and after drinking more alcohol, decided to return to the drugstore and pick her back up in the ruse that they were going to drive her back home. And that's when they took her back across to Kansas, they were still in Missouri, where the two teenage boys raped her. I wasn't able to find anything more other than Mr. Dusky attempted as well to rape her, but was not successful in that. But essentially, they brought her back to the town in which they had picked her up from. She kind of convinced them to pull over so that she could go into a place that she used to work to get a drink of water. They let her go in, and she went in, ran into somebody that she used to work with in there, and told the man that she had been attacked. And so they were obviously quickly arrested the following day after that. So because of the combination of the vodka and the tranquilizers and Mr. Dusky's history of mental illness, they used the insanity defense in an attempt to get him acquitted from the charges. He was hospitalized for a period of time prior to the hearing, and assessed by two different psychologists, one of which had really only been working at the facility for a couple of days when Mr. Dusky arrived there, and had never even done any sort of a competency evaluation. And he determined that Mr. Dusky was oriented to person, place, time, and that he was essentially, because of that orientation, was competent. A more experienced psychologist evaluated him and did not feel that he was competent, and gave more substantial information. But because there was no standard at that time in courts for what a competency evaluation should evaluate, they made the decision to go with that he was competent, and he was convicted and sentenced to 45 years in prison. Which so once they appealed that decision, and it went all the way to the Supreme Court, they determined unanimously, there was not even any dissenting voices from the Supreme Court, that there has to be standards for competency, that the defendant must have the ability to consult with their lawyer, and have a reasonable degree of rational understanding of the charges against them in the court process, and as well as a factual understanding of the process and the charges against them. So once he was re-evaluated, they determined him to be competent with those new standards, but his sentence ended up getting reduced to 20 years in prison at that point. But since that case, most of the states have adopted that those standards in the sense of being able to work with your attorney in providing your defense, and then to be able to have a reasonable degree of understanding of the process and of the charges against you.
Thank you, Jessica.
Yeah.
Any questions about that so far? I'm not seeing any in the chat, but I wanted to make space. Okay. Well, let's dive into Idaho Code. So Idaho Code 18211 is also in a response of what do we do about if somebody can't plead that they're the insanity defense, what needs to happen if there's a question of sanity? And that's where this code comes into play. So this essentially appoints a psychologist or a psychiatrist. They have to be licensed in the state of Idaho, and for hospitalization and potentially, and to provide a report to the court regarding a person's ability to aid in their own defense. And so in the code, that's what it's written right there in front of you, that if there's a reasonable doubt to their fitness, the court will appoint at least one qualified psychiatrist or psychologist to examine and report on the mental condition of a defendant to assist in the counsel of the defense or understanding the proceedings. And you'll see that a lot as far as understanding is a real key factor here. Understanding and reasoning are words that we're going to be using a lot. The appointed examiner will evaluate whether the defendant lacks the capacity to make informed decisions. And so in a court order, a judge can add additional things if they want to, because they're the judge. And we're going to be looking at kind of this two-prong approach of the understanding and then aiding in their own defense. And with the understanding comes reasoning. So just to let you know that competency can be questioned at any point in a criminal case. Often we see them start at the beginning, and usually it's like a defense attorney will ask the question, is this person able to aid in their own defense? However, I've seen orders where just the judge orders it because maybe during the arraignment, that first initial time they're in front of a judge, that there is something going on and the judge questions their ability to engage in the legal process. We've also seen it where somebody will be found competent and get treatment at North or South, one of the state hospitals, and then something happens, they go off their medications potentially, and before they're sentenced, the question is risen again about their ability to aid in their own defense. So literally anywhere in the process, we've seen orders come through. So here's kind of an example of how it usually happens. An individual is charged with a crime. At some point, competency comes into question. With that, an 18211 is ordered. Usually an 18 order directs the Department of Health and Welfare to assign a doctor to do the evaluations. And then that evaluator provides their opinion in a written report. So let me kind of flesh that out a little bit more. So first, DHW's role, Department of Health and Welfare's role, is normally we assign the psychologist or psychiatrist to do the evaluation, the competency evaluation. The court has and can assign their own doctor if they want to. That is up to them. In those situations, that's becoming less and less actually in the state, is they're finding it's easier just to assign it to Department of Health and Welfare to find a provider. And then we wind up tracking and just assisting wherever the psychologist or psychiatrist might need in the process. And to complete their evaluation, that might include report gatherings or letting them know, information as far as if they need records or whatever, because a psychologist or psychiatrist is entitled to the individual's records, medical records also. So then we also assist the court is, once they've determined if the person is competent, then we definitely get involved. So, in code, the qualifications of a psychiatrist or a psychologist is not very specific. It literally says someone that is identified as qualified, but we don't know what that means other than licensed, because to be qualified, you need to be licensed. And so we kind of depend on the psychologist and the psychiatrist for their own ethics requiring what qualifies them. Often that is that they've worked under supervision, they've been trained, they're getting ongoing education. There are national forensic conferences that I know some of our psychologists attend to keep up to date on what's happening in the nation and how reports are changed and improved upon over the course of time. So I have a question, and you can put it in the chat or whatever, is what's the difference between a psychiatrist and a psychologist? Any input there? Oops, I changed my thing. Okay. Cannot prescribe meds, an MD versus a PhD or PsyD. Yep. So here's a quick little diagram to refer to that. So yeah, they're a psychiatrist is a medical doctor, and they do specialize in both the kind of the soft science and the hard science. They'll look at what's going on with somebody medically, as far as their physical body symptoms that might be impacting their mental health, but also what's going on with mental illness. They conduct and prescribe medical treatments. They're experts in mental health, and they can often conduct psychotherapy. A psychologist refers to the study of. They hold advanced degrees. They have intensive training in clinical practice and research, and they usually specialize in psychological testing. So as far as Idaho, I am unaware of any psychiatrists that are doing forensic testing at this time. The majority of our individuals are psychologists, and they've, not that we have a whole lot of them. In Northern Idaho, we have one who does this as a primary evaluations, and we have two that sometimes the court will appoint, but those are few. They don't get appointed very often. And we have a backup psychologist who actually does Zoom evaluations from Twin Falls. And I don't have the stats on what is the rest of the state, but we're not talking.
In the East Hub, we have one primarily in Region 7 that we utilize, one in Region 6, and then the one in Twin Falls. So,
right. Yeah. Region 3 has 2 primary, and I'm not sure how many the Boise area has, but I don't think there's more than 3. So this is a pretty narrow field. So once somebody goes through the 18-11 process, they can get out of the system. They could be found fit and they exit the system. If they are found incompetent because of mental illness, they can be committed under Idaho Code 18-12, which is the determination of the fitness of a defendant to proceed. And if they are committed under this code, their criminal case stops at that point. It's held in suspension so they can get the treatment they need. So again, here's a little graph of that. The judge either rules to, so a judge is a judge, they get to decide what they want to do. They take the expert's opinion into play, but ultimately they can decide whether to commit someone or not. And there's sometimes different things will happen. Sometimes the charges might be minimal and the prosecutor decides to terminate the case before commitment. So there's a lot of nothing in the court system is absolute. So here's the process that happens is the judge either rules to proceed with the case as usual, and usually the person is fit to proceed, or the judge issues an 18-2-12 competency order, not fit to proceed. And like I said, in some rare cases, I've had like maybe the person has a misdemeanor or a very minimal crime and they're not fit to proceed, but the family will present a plan to get the person treatment. And in some of those cases, I've seen them not go to commitment. The judge lets the family figure out what needs to happen. Once that happens, if the person is deemed not fit to proceed and the judge chooses to move forward with treatment, court-ordered treatment, a commitment order happens and the person is committed to the Department of Health and Welfare. Typically, these individuals are incarcerated. However, sometimes misdemeanors, they don't need to be incarcerated, and so they're in the community, and so they can be committed when they're in the community. And they are usually then directed to contact the department. There's a few other unique cases which we'll talk about later. And then after commitment, the goal is that within 3 or 4 days, they are seen by a Department of Health and Welfare clinician, which does a mental health assessment and then determines what treatment they need. Again, the majority of these are referred to the state hospital for restoration. So I wanted to go into kind of what it looks like for a psychologist or psychiatrist to do in a competency evaluation. So competency is a legal concept referring to the mental capacity to decide in accordance to one's goals or concerns or values. Competency is absolute but not specific. So either the person is competent or is not competent to make a particular decision. So while they could be competent to even function in their job, they might not be competent to aid in their own defense because of things that are going on with them. Competency is fluid and it can change over time. That's why we have a restoration process. Oh, why is that not? Hang on, my thing is there. So competency is, in general, the decision is about the decision-making ability, and with the legal focus being, is there an understanding of what's being discussed? Who are the people in the room and what options are? They also look at appreciation, what is the significance of the information being presented, what to share and when to share it. And then also, sorry, let me go back there. Reasoning, which is the ability to sort out and make sense of the information that's being discussed. How it makes sense to them, and are they making good decisions? Because, well, I shouldn't say good decisions. What is their decision? Is like, are they making it because there's voices going on and telling them that's not good reasoning, but they can make poor decisions and still have reasoning that's intact. Okay. So again, competency is also looks at informed consent. with that, we look at an individual has a right for self-determination. Their decision-making is reasoned and rational. It takes in appropriate information. It's a voluntary decision. It can be yes or no. But even with competency and reasoning, the person is still allowed to make foolish decisions because that is a value decision, right? Why they're making the decisions they are. So when we're talking about mental illness in this, we're talking about how Idaho code defines it, because the code drives everything on the determinations that are being made. So in Idaho code, there is mental illness is defined, and that IDC 66-217 parentheses 11, that is a code in the state of Idaho, and it is defined this way, that mental illness means a condition resulting in a substantial disorder of thought, mood, perception, or orientation that grossly impairs judgment, behavior, or capacity to recognize and adapt to reality, and requires care and treatment at a facility or through outpatient treatment. However, the term mental illness does not include conditions discussed in 66-329-13. So I will talk about that in a minute, but I was thinking about the example of how the code works sometimes is those of you that are familiar with the DSM, there'll be a definition and things like that, but you've got to jump over to another section to try to sort out what that really is including or excluding. That's the way the code kind of works too.
And it looks like Mary just put the link to that statute in the chat for anyone that loves to read statute.
There you go. So diagnostic examples of that, psychiatric disorders would be that impaired thinking and or judgment. So our reasoning can be influenced by depression, mania, severe anxiety, psychosis, delusions, and PTSD. Of course, there's other things, but those are kind of the primary ones that we see. There's also disorders that can impact that, which are less common, which is dissociative disorders, fugues, and then catatonia. So those are not limited, those are just examples. So by code, what is not mental illness? Neurological impairments, substance use or abuse, developmental disabilities, and medical conditions. So again, it's not that we know that the DSM classifies substance abuse as part of a mental illness, but by Idaho standards, that is not considered. So I wanted to look at each of those a little bit more. A neurological impairment, so going back to the definitions. So 66-329 code is about civil commitment, and they have exclusions that the criminal code references as a standard. And so in that code, the neurological disorder means a decreased mental functioning due to medical diseases other than psychiatric illnesses. And these are the ones that are specifically named: Alzheimer's disease, frontotemporal lobar degeneration, Lewy body dementia, vascular dementia, traumatic brain injury, inappropriate use or abuse of substances or medication, infection, HIV, Crohn's, Parkinson's, or Huntington's. So all of those impact somebody's neurological functioning is what the code has decided, and that's the standard that we operate from. It's, of course, it says includes, but that doesn't necessarily limited to, so there could be other ones. Substance use, it's disqualified in the 66-329, and I wanted to give a definition of what the National Institute of Mental Health defines it as, which says that it's a disorder that's treatable. It's a mental disorder that's treatable, that it affects a person's brains and behaviors, leading to their inability to control their use of substances, legal or illegal, alcohol or medication. So while we as professionals consider it a mental illness, the state of Idaho does not let the Idaho code treat that. It's basically because the state system cannot treat cognitive issues or substance issue at the state hospitals. So developmental disability, I wanted to look at that a little bit. Again, another Idaho code is 66402, and that is about individuals who are involved in the system and has developmental disabilities. Developmental disabilities is defined as a chronic disability of a person that appears before the age of 22. So this is for Idaho. This has nothing to do with any other states, and this is the standard. Of course, we have people who are over the age of 22. Maybe they were never involved in education. Maybe they were from another state, but in the state of Idaho, unless they can be identified as having a disability before the age of 22, they do not qualify for services in the state of Idaho, and they do not qualify to be treated under this code. So there's a lot of ands, and that's really important in this. So you can see the first one is there's an attributable impairment with intellectual functioning, cerebral palsy, epilepsy, autism, or other conditions found to be closely related to or similar to one of these, which impacts or impairs and requires treatment or services, or is dyslexia is included in that, but it has to meet some of the other requirements. What I do want to point out in the state of Idaho is Asperger's is not considered a mental illness. I mean, sorry, not a mental illness, a developmental disability where autism is. So even if someone has one of those disorders, if they do not qualify for the other two, they will not qualify for developmental disability. The second one is a substantial functional limitations in 3 or more areas of major life. So care, language issues, learning, mobility, self-direction, capacity for independent living, and economic self-sufficiency. They also have to qualify for the C, reflects the need for a combination and sequence of special and interdisciplinary care and treatment or other services of lifelong or extended duration for individual planning and, sorry, my chat box over that one, coordination. So during an evaluation, these are the things that a psychologist or psychiatrist is also looking for. Is there a medical condition going on? Is there substance conditions going on? Is there developmental disabilities going on? So I have a question. Yeah, Nikki, I don't know. So her question is, Asperger's is no longer viewed as separate from autism spectrum disorder. So how does that work? I have not heard how that works. I just know that in the past. Jess, do you know?
Essentially, when somebody has a history of diagnosis with Asperger's, if they are being seen by a psychiatrist or a medical doctor or anything, most of those individuals, their diagnosis, if they meet criteria, it is changed to the autism spectrum disorder. The only time that becomes a challenge is when somebody has been diagnosed with schizophrenia and they have a history of Asperger's, that the schizophrenia basically kind of overrules the Asperger's, and so they can't actually qualify for autism spectrum disorder anymore.
Mm-hmm. Right. And again, it's like no matter what the diagnosis is, if they have to meet the other criterion, right? It's not says it's and that they have these limitations in functioning and. So thank you. Good question. So medical conditions, I just kind of wanted to highlight this a little bit. So some of those can be strokes, seizures, urinary tract infection, cancers. There's lots of mental conditions that can impact someone's reasoning and understanding, but those are not conditions that are considered mental illness, even though some of them can look like it. And so they're not treatable in the state hospitals, because the state hospitals do not do a lot of medical treatment. They do psychiatric treatment. And so those are disqualified. And then the doctors, how they do the assessing is they gather information. They try to get history, collateral information. Their goal is to establish what the current functioning is, but also what the previous, their baseline functioning is, to make informed decisions and inform the court of what's going on with this individual. So for history, they'll gather from school if they can, work, family, find out if there's a history of mental illness. Were they functioning, 3 months before they were incarcerated, and now just to understand what's going on, when possible mental illness started, and is there, what's the whole dynamic that's going on. Collateral information, again, can be from family, they can be from medical records, they can be from DHW records, they can be from the jail, criminal history. All of that is looked into and taken into consideration while they're forming their opinion. Because again, they want to understand what the baseline functioning is versus the current functioning, to help them make a determination of what's going on and what might this individual need. So they also then figure out why is the change? Was it because of substance? Was it because they had a stroke? Was there something, what was going on? And then what do they need as far as is medication, is substance abuse treatment? Because the psychologist can recommend substance abuse treatment over mental illness treatment. And is there a hope for restoration? So I had an example of one case. The individual had, I believe it was a DUI so I think it was either the end of 22 or the beginning of 23. He had a DUI. When his case came to court, he had actually had a stroke in between those two times. His competency came into question, right? Because his functioning had really deteriorated. It was so early in the process, they really didn't know what the prognosis was. And so the evaluator said, the guy's had a stroke. We don't know what the outcome is going to be, if he's going to rebound on this or not. And I can't make a determination on really a recommendation. So in that situation, the judge decided to postpone it, I believe, for 6 months. It might have been 9 months, but they postponed it to let the individual potentially have time to improve with treatment and to see where things are. So the evaluator really is looking at a lot of different things to be considered. So. Well, now what's going on there? Okay. So some of the tools that a psychologist or psychiatrist will use are because their determination is not made solely because of tools that they use, the assessment tools, but it's their clinical decision also. But the more information they gather, the better, right? So the MacArthur is a tool that tests reasoning, understanding, and appreciation. It gives scenarios and asks questions about it, just so the individual can answer, and the psychologist can determine whether they're making sound decisions, whether they understand the roles. It'll ask, what are some of the roles of the judge? What does a jury do in a trial, and things like that. I'm sure anybody who's worked with clients are probably familiar with the MFAST, the Miller Forensic Assessment of Symptoms. That is a scale that is used to identify malingering or feigning mental illness for secondary gain. That's used very frequently because there is a lot of people that are, I mean, you're dealing with a criminal process, and we do have our share of criminal-minded trying to get away with getting off on because of mental illness. They might not even be aware that there's no insanity plea in the state of Idaho. So the MOCA is a cognitive assessment tool that's used pretty wide scale. The V-Risk 10 is a violent risk assessor because we do want to know, is this person violent, to help determine what is the next best step in treatment for them. The CAST-MR is the competency assessment for standing trial with defendants with mental retardation. It's valid for individuals with low IQ. So again, somebody can have low IQ and still have a mental illness and need treatment and not qualify under the DD services. So this is a lot easier tool to evaluate individuals with, I think it's scaled for like about IQ less than like 76, I think it is, maybe 75. And so then also the ECSTR, that's also kind of like the MacArthur as far as rating on what their understandings and appreciation are. They also will use things like the brief psychiatric rating scale or the PS10, whatever kind of things tools they like to use for assessing mental illness. I've seen some use the Milan, and they don't use the Minnesota. The MMPI is the big one. They don't use that so often because it takes so much time, but they can use any assessment tool that they deem appropriate.
And wouldn't you say, Dia, we oftentimes see individuals who are so decompensated during that assessment process that they're not even able to participate in any sort of a standardized evaluation.
Exactly. Yeah, that's exactly it. It's the ideal versus what sometimes happens, because if somebody is catatonic, there's no way they're going to engage in it, or they're so disorganized. So that's where the history and collateral context really plays into helping the psychiatrist or psychologist define what's going on. So let's say they decide a defendant lacks the fitness to proceed. In that, the court determines that the defendant lacks fitness to proceed again, and the proceedings will be held in suspension. The court then commits them usually to the Department of Health and Welfare, and that commitment cannot be for more than 90 days. That is for the care and treatment in the facility determined by the Department of Health and Welfare. So I wanted to talk a couple other types of commitments. So there is a developmental disability commitment. I don't know all the ins and outs of that. I will just tell you that they are committed to the department also, and the developmental disabilities program works with them. They're most often in the community when they happen, at least in my region. And though if they are dually diagnosed with developmental disabilities and mental illness, they can be treated at North if State Hospital North or State Hospital South if their primary issue with competency at that time is deemed to be mental health, okay? So if it's mental illness, they can be treated at the hospital. If it is primarily developmental disabilities, they cannot be treated at the hospital. The other one is 66-1305. That is an add-on that can be added on to either a civil or a criminal commitment. And I don't know if you guys have heard a lot about that. This has been kind of a buzz in the news lately. I'll get into that in a minute. But this code is for individuals who are deemed dangerous and mentally ill. So I wanted to dig in that a little more, and the code is very simple. This is it. So it's dangerous and mental ill person is defined for the purpose of this chapter. Persons found to be both dangerous and mentally ill shall mean persons found by a court competent jurisdiction pursuant to any lawful proceedings. 1, to be in such a mental condition that they are in need of supervision, evaluation, and treatment and care, and to present a substantial risk of physical harm to other persons as manifested by evidence of homicidal or other violent behaviors, or evidence that others are placed in reasonable fear of violent behaviors or serious physical harms to them, and to be dangerous to the degree that a maximum security treatment setting is required. So we struggle a lot with this, I'll just tell you, because doesn't flesh it out very much. So often it is the clinicians of DHW that are helping define if somebody does meet this criteria. The main takeaway in this is because someone has done a violent act does not necessarily mean they immediately qualify for DMI. So someone can they're accused of murder, and they can be as docile and in general population as anybody else functionings is. So they've done a violent behavior, but they are not acting out now that puts other people in jeopardy. So we sort that out a lot. We look at the main line. Do they, at this point in time, for treatment of their mental illness, do they need a maximum security treatment setting? Do they need trained professionals that are used to dealing with violence, because the state hospital is not used to dealing with violent behavior? Jessica, you have anything?
Generally, when I assess for that, we're really looking at how difficult are they to manage in the jail setting. An individual who's maybe in special housing for their own safety, maybe they've got suicidal behaviors, things like that, versus somebody who's in special housing and it takes 3 or 4 officers to be able to get them out of their cell because they are so assaultive, or they are not able to remove them from the cell without them becoming assaultive, that they would not be able to be managed in a psychiatric milieu where it would put the other patients at risk of harm. So that's really what we look at, in the sense is if they're able to be managed in general population, or they're being currently managed on a psychiatric unit in the community, then they would not meet that criteria for a DMI.
Right. Yeah, so thank you for highlighting that. We'll go into a little bit more of what beds are available for that. But again, somebody under a civil code, so they've not even committed a crime, they can be deemed DMI and sent to the maximum security prison. And again, that's very vague, but we have to assess the violence or the risk of hurting others. So you have anybody, I want to stop and see if anybody has any questions or anything like that at this time. Okay.
For an example, in the sense of how I've seen this play out with somebody under a civil commitment, is that somebody will be in a psychiatric facility in the community and becomes assaultive to a peer or a medical staff, and end up the police end up getting called and they get arrested and placed in jail because they're not safe in the community hospital anymore, but they were already civilly committed for treatment. And so then this would go back in front of the judge for additional testimony to add the dangerously mentally ill component to the commitment.
Perfect. Yeah. Yeah. Thanks for pointing that out, because it is not DHW that makes the final decision. It is the judge. And we have to often fill out an affidavit and explain to why it's our opinion that the person needs this qualification. And at that point, if they are deemed dangerously mentally ill, the judge will kind of suspend the commitment to Department of Health and Welfare, and then appoint them to be in the custody of IDOC, Idaho Department of Correction. The other thing is they can be stepped down, so they don't go to the maximum security prison and stay there until they're restored or deemed stable or whatever. They can be stepped down back to the hospital once that danger has been assessed and is no longer an issue. So let's look at what treatment looks like, and then also determination of disposition, which is where they get their treatment. So in the code, a disposition talks about once they're committed, they can be treated at IDOC, as we discussed, or a DHW facility. And so most facilities, again, what I had said earlier is most people go to one of the 2 state hospitals that we have that treat mental illness. However, they can be in the community and get treatment from the local mental health office, or they can be treated at the community hospital for restoration. That is not happen often, but I'll talk a little bit about Intermountain and what they provide for us in a later slide. So I wanted to give you guys pictures of kind of what those facilities look like. This is a front picture of State Hospital South, which is in Blackfoot, Idaho. It was established in 1883. Idaho wasn't even an state yet. When people were committed to the hospital, it was a lifetime commitment. They could be committed there because of mental illness, because of civil issues or criminal issues. Just to show you as an example of how big this was, in 1953, there were 766 people at State Hospital South, which was one of the 2 hospitals. It was very large. It had a whole farming community wrapped around it. When you think about Idaho in the early years, that is who people were they mainly farmers. And so they had a farm there, so people could do farm activities and live life there. It is reported to have one of the premier Holstein herds in the West in the early 1900s. And
it was essentially self-sustaining, wasn't it? Where they grew their own food and produced their own milk through.
They did. They were self-sustaining, and they also would ship those things to State Hospital North and support State Hospital North that way also. So like in looking at the cases, especially like with Mr. Dusky, 1953, there was no really treatment with an antipsychotic. The first antipsychotic was I believe it was 58, was Thorazine, and it was researched at State Hospital South. This building was built in 1988, and it has 106 beds. I've never been on the campus there. Those of you guys that are familiar with it, might know if there's any old buildings or anything left, but I think that
There, yes, there is. There's, I believe one of the old treatment facilities that's been fixed up a little bit has the gym and security housed in there. They have torn down a couple of the other buildings. And then they do have some older kind of side buildings and so forth that small little homes and things that are on that are not in use anymore, but are still present. And they just barely filled the tunnels in maybe 5 to 8 years ago. But prior to that, they had the tunnels that went underground from all of the different facilities so that they could transfer the patients through the tunnel system instead of, because it's not the campus is not a secured campus.
Cool. Thank you.
And there's also a cemetery
Yes.
there.
Yeah, almost any old psych hospital facility will have a cemetery. So this is a picture of State Hospital North. The big picture is their front entrance. The side, the lower picture is kind of a side angle. State Hospital North is in Orofino, Idaho. It was established in 1905 by sending up, I put 25 patients, I think it was actually 20 patients and 5 staff from Blackfoot were sent up to Orofino to establish the hospital. They built the old buildings and occupied space. They built this building in 1994 and tore down the other buildings. If you've not ever been up to the campus of North, there is a prison right behind it, and I think they use some of the old buildings in that prison, but they also have some old houses that a locum doctor might stay in or something like that. The State Hospital North has 2 units and they have 55 beds. I wanted to highlight Syringa Chalet as it's also a treatment facility, but not for the 18s. It is on the campus of State Hospital South. It is a skilled nursing facility for people who are committed under the civil code and addressing their geriatric needs. So this building was, Syringa was started in 1991 with using one of the older buildings of State Hospital South. That building was grazed and this one was built in 2019. It has 48 beds. It's a combination of single beds in a room and double beds, depending on an individual's needs or wants. And again, they do not do restoration there. This is only for individuals with geriatric needs that are under the civil commitment. It is not a temporary treatment facility. It is kind of deemed that this is where people need to be for the rest of their life because of their their skilled nursing needs and their psychiatric needs. The other 2 places that people can get inpatient treatment is the Women's Correctional Center in Pocatello. We have 1 female bed designated for dangerous and mentally ill. And in that, they are segregated in their own cell in the regular unit. It is, if that bed's full, we have to figure out what else is going to happen with that individual. Unfortunately, after that means they stay in jail. The picture below is the IDOC in Boise area. There are 9 beds segregated from the general population on the medical unit, and those are for men, and that went. Anyway, again, if the beds are full, they figure out something else to do. As I had said, you might have been hearing about the hubbub of a new hospital being designed, getting funded for the dangerously mentally ill that has just been passed by our legislator. It is not a DHW facility. It is being funded for Department of Corrections. And as I understand it, in the past, the conversation has been that they have property on their Boise campus, and that they'll probably be building that facility there. I don't know the ins and outs of that because I've not really delved deep into it. I'm hoping that they will actually include women there because the Pocatello facility, is really limited in their space to provide treatment for women with mental illness and needing restoration. Any questions or anything? So what we look at when we decide the disposition is what's the least restrictive alternative and where do they need their needs can be met for restoration at without going to a higher level. So of course, IDOC would be the highest level, and we try to not send people there if we can get away with it. The state hospital is also considered a higher level of need. I just wanted to highlight on why somebody might go to north or why somebody goes to south. In the northern area, that is where Orofino is located and State Hospital North is located. And so Region 1 and Region 2 and some of Region 3 individuals are sent to State Hospital North, I would say 98% of the time. There could be some problems if there's a conflict of interest, possibly. I mean, you could imagine if somebody is committed out of Orofino and it's not a very small town, they very well could have 3 or 4 family members working at Orofino. In those situations, if there's a conflict of interest, they will send somebody to State Hospital South. Same thing with State Hospital South is part of Region 3, but then the rest of the state goes to there. There's, as I indicated earlier, Intermountain is doing community hospitalization. They are have undergone some training, and they will take some individuals needing restoration. This is so far they've only been from Region 3, and the region works closely with the hospital to identify appropriate individuals that go there. We do have a couple of other hospitals that are considering possibly following this model, but nothing's been determined yet. Somebody is usually deemed appropriate for community restoration if the court has already released them, right? It would be very hard for me to get somebody out of a jail to do community restoration if the judge wasn't on board, because I'm not going to post bail for them. Though the judge sometimes will take into consideration, and in my situation, they'll ask me if I think it's appropriate. And if I've met with a person, I will let them know whether I think it's appropriate or not. Just because somebody might start off on community restoration doesn't mean they will stay that way. It depends on the individual. I've had individuals who do come in, meet with me. They are cooperative, they're willing, they want to get done with their treatment as quickly as possible. They'll do whatever I recommend with starting meds and meeting with me regularly, and they just proceed forward rather quickly. I've also had those who will meet with me, but because of various reasons, cannot get psychiatrically stable in the community. That could be because they're not willing to take meds. It could be because they're not willing to stop substances. There's a big gamut, and in those cases, I will make recommendations that they go to State Hospital North. And most of the time, the court will help with that by taking them into custody. Jessica, do you have any examples or comments?
We don't often do community restoration in the East Hub, primarily because there's definitely a benefit, I think, to having somebody in custody and on a milieu to be able to monitor and rule out that malingering and those sort of symptoms. Somebody can present for an hour, a couple of times a week, and kind of appear how they want to present, but it's nearly impossible for someone to feign those symptoms 24 hours a day. And so when they're on the milieu and able to be monitored, interacting with their peers and with staff and things like that, it seems that they're much better able to kind of tease that out and determine who truly is using that for secondary gain.
Right, yeah. So I'll give a couple examples of my clients on what on community restoration. So I had one individual working. She was doing well, basic in life. Her charges resulted around an excessive use of meth, and got really paranoid and even called the officers on herself. And so she was never put in jail. When she was deemed not fit because of her depression, even in meeting with a psychologist, he had said, listen, you need to go start some medication and get this turned around. She was very receptive to that. And by the time she was committed, she had already started medication. But she also was pretty naive about the whole judicial system. And so while we're not really designed to educate people, through the whole process, there are occasionally people that are just clueless about it. And so I kind of talked to her and gave her education. She had a workbook she worked through. She had flip cards that she did, flashcards, and she maintained working, and she maintained her house. And instead of have a disruption to the degree of losing her job, losing her housing and all of that, the community restoration was successful. She met with me religiously, I'll put it that way, because she was so invested in succeeding. And she successfully was restored to competency, and her case went forward. It was really a win, because I'm sure you all can, you might even have had clients that have gone to the hospitals, and their whole life can be interrupted. They can lose their housing, they can lose their job because they don't have any income. And so with that individual is very successful. I had another community restoration person. This person was actually, he was never diagnosed with developmental disabilities because because of his age, because of his lack of going to school, and because he grew up in another state. He now lives in Idaho, and he was obviously not functioning at the standard that he needs to. Because of lack of alternatives, the judge committed him to the Department of Health and Welfare. He was in the community. I worked with him, and he was very willing to do whatever he needed to do to the degree that he was able to do it. He was very eager. He would come to every appointment and participate to the degree he could. It wasn't very successful, as you could imagine. But I worked with him trying to help him understand the process. It became pretty evident quickly that he was not ever going to be able to understand the process. So I took a second approach, and I decided, here's an opportunity. He has somebody speaking into his life. He decided that I was a trustworthy person. And I started talking to him about poor choices that he had made that led him up to his criminal commitment. He had low boundaries, and he let a lot of people live in his house that was doing substances. And so I told him he had to stop, and he needed to set boundaries and really talk to him about what it meant to be a friend and have a friend. And that's what our treatment focused on. It wasn't ideally the way the law was established, but it was an opportunity. And so I reported to the court that this individual was never going to be able to stand trial. And however, I saw him probably a year after his commitment, and he had moved over to Washington and was not having any contact with poor choices in friendships. He actually had met a young woman who also had some developmental disabilities, who had a really supportive family, and they were going to get married. And her family was helping him establish healthy boundaries too. So those are some of the situations that in my area that we've seen for community restoration. So our judges tend to like it. And so we get pretty creative with that. Any questions, comments? Do any of you guys have any experiences with individuals going through the commitment process with the people that you work with? Please just feel free to speak out. I can't see the hands. Is there any?
Not seeing any.
Okay. I'll tell you, the first, this is how I got involved with the criminal commitments, it was a community restoration situation that was assigned to me. And so that was probably about 9 years ago, maybe 10, that got me started on really focusing on in this area for my professional life. I did want to highlight too, just kind of the change that we've been seeing in the state of Idaho with criminal commitments. So when I first came to Idaho, which was about 20 years ago, our region had a woman who was at state hospital because she was accused of murder, but deemed incompetent. Subsequently, she was never restored to competency, and we'll talk a little bit about that in a minute. But I had to kind of annually make sure she was civilly committed. Fast forward until about 10 years ago, I had this community restoration, and then we started having more and more evaluations. In the last 5 years, I would say the number of individuals being committed to Department of Health and Welfare because of mental illness and criminal charges has increased about 400%. It is astronomical, the amount of people that are coming through this process. And so
and the patients that are committed under the competency under 18212 are priority admissions to the state hospital. Good. So there's always a waiting list at both of the state hospitals. And so anybody who gets committed for competency, they jump ahead of everybody else for admissions. So the more that we see with these hospitalizations, we're seeing a lot more of the civil commitment individuals staying in the community hospitals longer as well.
Yeah. So Mark asked, are all patients in hospital DMI? No, they are. They have been, any of them at the hospitals are stepped down from that classification of DMI, because to be classified as DMI, they have to need identified as needing maximum security. So they can be stepped down from the IDOC to the state hospital. So they had the classification of DMI, but they're not considered DMI anymore. They also could have a previous commitment as DMI, but they don't meet that criteria, and so they can go directly to the hospitals. if that helps explain that. We don't do DMI in the community. We have them go to.
Yeah, they have to be severe enough that they are even very difficult to manage in a local jail.
Mm-hmm. So here's an overview of it. What treatment looks like is they do competency restoration curriculum that can look like individuals or in groups at the hospitals. They have workbooks that they work through. Of course, medication is the first and primary target that is used to address their mental illness. The being in the therapeutic milieu is very beneficial, and they have other groups besides competency groups that they would engage in, whether it's recreational or symptoms management, or there's just each hospital has their own groups that is open to their patients. They'll get individual case management and treatment planning. They get that in the community also. Assistance help with setting up healthcare benefits. So that's often a big part of the community restoration, is we want to make sure that they're connected to getting their medication. When they're getting ready to leave the hospital, depending on if they're going back to the community or going back to jail, the hospital might help them get set up with benefits. And then also they get assistance with discharge planning. What's it going to look like when they leave? Where might they get their meds, and connecting with resources they might need.
I know at State Hospital South, the individuals that are under the criminal commitment are confined to the treatment unit. They are not able to get grounds privileges.
Mm-hmm.
Is that the same up at State Hospital North?
Yeah, they could get furloughed if there was something that needed to happen, like they needed a tooth pulled or something. But they're very cautious on letting those under criminal commitment leave the building.
Mm-hmm.
Yeah.
Let's see.
So what might happen after in this first 90 days is they can be.
Question in the chat real quick.
Oh, go. Okay. What percentage of people enrolled in or waiting competency restoration are unhoused?
What do you mean by unhoused? Clarify that. Sonia, if you can
Homeless. Oh. So you mean homeless even if they're in jail?
Right, coming in as homeless and not having a place to go upon release.
Mm-hmm. Okay. I don't have the stats on that. Do you have a jab?
Generally, I mean, I would say we definitely see that, but since a majority of the individuals who go to the hospital for competency restoration return to the jail, then we aren't involved generally in that discharge planning process. I know our community jail has social workers in the mental health department that help with discharge planning from the jail to be able to ensure that they don't just get released to the streets, but I don't know the specific stats on that, but we definitely see that. If they are somebody that can bond out, and I mean, we also in the discharge planning process, even if they're returning to jail, can definitely get them familiarized with the resources and the options once they're released from jail. And they're always given the contact information for the region if they're released from jail and they need assistance with locating any of those resources. So sometimes they'll get in contact and we'll help them after they've been released.
Right. Exactly. Thank you.
What percentage of those have I, once again, I don't know the percentage, but I would say I've seen it happen. a handful of times
Mhm.
each year. So,
Yeah.
and
We
it's generally because when they go back to jail, they start refusing medications. And a lot of the times they're in special housing, so they're isolated, and for people with severe mental illness, isolation is not helpful for them. So
Mhm. In my hub, I would say we kind of have probably 3 that every process of the court case, they're going back to the hospital. It might, and maybe I should expand that to, I'll say 3 to 6. They, because they return to jail or they're released from jail and they stop their medications. And then the next time they're in front of they deal with their attorney, their competency is in question again. And so it's kind of like every step they just do a stint at state hospital before they they proceed to the next situation. We've even had individuals where they are waiting sentencing and they're deemed not fit to be sentenced because of where their functioning is. So it really can, if they choose to refuse medications, it can really prolong the case.
and we've I live in Idaho Falls, and which is the Bonneville County, and within our Bonneville County jail, they were noticing a lot of those individuals coming back because the court process is paused for them. The individual would return to the jail, and oftentimes we're kind of falling through the cracks because the majority of them have public defenders, and they maybe aren't familiar with who their attorney is, or the attorney isn't notified that they were returned, and so they wouldn't have a hearing scheduled for a long time. So we actually have a monthly meeting where the people from the courts, a judge and the public defenders and health and welfare, we all meet together and just make sure that the individuals that are returning to the jail have court hearings scheduled as quickly as possible for when they return, so that we can try to prevent them from decompensating and having to return back to the hospital because they had to wait so long for a hearing.
Perfect. And I think that that's really kind of what was working 5 years ago with so many fewer of them going through the process is not working today. And so the courts and the department are working together to try to figure out what is best for getting these cases going forward quickly, and also putting input into helping the courts understand that if somebody was on a medication treatment override, they don't want to take meds potentially, and so they need to process these quicker because they're going to stop medications, because again, competency has its limitations, and it can change. And so it's been a huge learning curve for everyone involved. And that's kind of what my role is starting to take on, and the peers in the rest of the state is we're trying to help facilitate those things quicker. I will try to communicate with the attorneys, letting them know that, hey, be looking for this, be moving forward on this and things like that, because information helps.
Definitely.
Okay, none others in the chat, then we'll move on. So what can happen in that 90 days? First, the person can be deemed fit, right? They've got the treatment they need. Their case resumes, and that happens after the staff at the hospital submit a report to the court about what treatment the person is engaged in and what their functioning is now, and that they are ready to proceed with trial. Or hearings necessarily, it might not always go to trial. But anyway, so what normally happens is they're transported back to the county where they're from. Usually that is with the department, with the sheriff's department. However, a couple month or so ago, I had a guy, he was in the community. He was not participating in treatment. We went to court. The judge asked me if I wanted him detained or not. I felt bad, and so I wimped out and said, I'll leave that up to you, Your Honor. And she decided to let him be in the community and asked if I would transport him to the hospital, which I did. And he showed up the times that she told him to make sure that he was going along with the program. And so then when it was time for him to be released, I went and got him also because, nope, I take that back. With him, the sheriff did drop him off, but they didn't book him. They just transported him down for me. So it's not 100% on anything, at least in my region, because North is so close to where we're located. So they come back to usually the jail, and their case moves forward. If they're still deemed unfit, there is a part of the code that says that there's a substantial probability that the defendant will be found fit to proceed in the foreseeable future. Excuse me. And so in that situation, and if North or South requested, their commitment could be extended for another 180 days. Sorry about that. So, Jessica, can you pick up that?
So if the court continues that commitment for the 180 days, then that after that point in time, a determination has to be made of whether they're going to be fit to proceed at that point, or if they've determined now that there's no possibility that they will be fit to proceed. And then they will generally move forward with the civil commitment proceedings, because they're generally in the hospital setting at that point and still need to be in an inpatient setting. And so they will then move towards the civil commitment proceedings. And with there's a handful of individuals that have severe enough charges that, but they're not going to ever be fit to proceed, where we do an annual civil commitment and monitor those individuals through outpatient commitments in the community to make sure that they're maintaining that treatment.
Thank you for filling in there.
Yeah.
So again, so if they for those of them that are committed for that extra 180 days, they can be restored to competency, and then things move forward. And if not, then they're evaluated under the civil code. I had one individual who he was never going to be restored to competency. He probably technically had Korsakoff's, and but he had his own independent living, he had his own means, and so he was not committed under the civil code, and he returned to the community. Those cases, they can be dismissed, but they can also, if they're ever deemed fit in the future, can be reopened. So I wanted to highlight a kind of a landmark case in Jackson versus Indiana about why we have that 270 days. So there was an individual in Indiana, Theon Jackson, 27-year-old. He was held without due process in Marion County, Indiana. He was considered deaf. He was nonverbal. He didn't know how to read or write, really. And even his sign language, his ability to communicate was very, very limited. And so he was technically, his charges were just that, what amounted to $4 and $5 theft. He the state deemed him committed to a mental institution until he could be deemed sane. And luckily enough, Mr. Jackson had an attorney who challenged that, saying there's no evidence of him being insane. And so then it went to the Supreme Court, and this below is what the Supreme Court deemed is that a person charged by a state with a criminal offense who is committed solely on the account of his incapacity to proceed to trial cannot be held more than a reasonable period of time necessary to determine whether there is a substantial probability that he will attain the capacity in the foreseeable future. And so I'm not going to read the rest of that, but that is why we in the state of Idaho have a limited amount of time, because it's so people are not being held indefinitely, that they are getting due process of law with their charges. And so that's why our codes say that they have to be evaluated for the civil if they still need to be in a hospital or in the care and treatment of Department of Health and Welfare, but they're just not going to be held indefinitely either in jail or in a state hospital. Did you have anything, Jessica?
There's just a couple in the question and answer box that I am seeing. Sarah asks, when a person scores high on the MMSE, is that the mini mental status exam? Is that, but the person shows visible signs of schizoaffective patterns. How do courts determine their true cognitive ability? Which, I mean, essentially in that, what we're looking at is somebody's history. I mean, somebody doesn't, live a functional life and hold down a job and have no history of mental illness. And then when they're 67, they develop schizoaffective disorder. So if they generally have some history of mental health, and then so if they have a diagnosis of dementia, but they also have a history of the schizoaffective disorder, it's really looking at what are the symptoms that are presenting, and are those symptoms going to be treatable? Are we seeing primarily symptoms of the dementia, or are there some breakthrough psychotic symptoms that can be treated with medications? And I don't think that there's one specific way that they would determine that. It really, I think each individual evaluator would look at all that history.
Mm-hmm. Right. So also, I'll say, at least with the evaluators that I deal with, if they're not sure, they will err on the side of possibly they're restorable, and so they get a try at State Hospital North, because you just don't know until you kind of weed out some of that stuff. So often they'll go to North, and then not North, State Hospital, and one of the providers there will then make a final determination on what really is going on.
Mm-hmm. Sarah also asked, can the state file for guardianship with this evaluation? I think we're going to talk about that, but no, that guardianship is not something that can be done under this. Is there information resource regarding 18 years of age client under 18? I don't think there is a competency for juvenile.
There is.
Okay.
So yeah, I was gonna highlight, I think I kept that in there. Maybe I didn't. I'll just talk about it now because we'll kind of focus on questions. So there is an adjudication process for minors. I'm not well versed in that because I do adult mental health. but I think it's, so they have to be evaluated. There are some in the community that will work with treatment providers, or they can be put to the juvenile detention center here in Lewiston that helps with that too. But I'm not well versed in that at all because I am not a children's expert.
And then Sarah, she says that this particular person pays her bills, buys her groceries, but is well known through our community to have a pattern. She has a court hearing next month for an assault, which I have viewed the tape and it is malicious. So a judge can order them into a state hospital, which the judge does not order them into the hospital. They order the commitment to the Department of Health and Welfare, and then the department determines where appropriate treatment.
Yeah, exactly.
So, as far as this individual, I guess I'm not real sure if Sarah, can you unmute and maybe share a little bit?
Yes, of course. Thank you. So I have been working with this individual in our community. She is very well known to create problems. She has been banned from several businesses. We worked on reestablishing those connections, and things were good for a hot minute. But recently, we are seeing not just a cycling, but an escalation in her violent behaviors. I worked with the state from gentleman from senior services. He did the MMSE. She scored like a 25 out of 30, which I was blown away, first of all. But her behaviors in the community, like using her fingers as a phone, feeling that somebody is tapping into her telephone, her landline. We worked on getting a new fridge, getting a plumber coming out. All this was going to be free to her, but she denied services, so she now doesn't have running water, which of course is not essential because she's using gallon water jugs and doesn't have bags of urine and feces. But she recently has escalated to a violent behavior, and this violent behavior escalated to her grabbing a young lady and throwing her into her truck. And then the behaviors after that, the verbiage that she used, are also caught on tape. But she is very schizoaffective, very paranoid, but she doesn't have a PCP, so that doesn't help us. And I just don't think jail is the right place for her. And I've talked to the family with her permission because I just so serendipitously met with them at her residence. And I have requested that, the son needs to file for guardianship at this point, or else she's looking at jail time, which is not where she belongs, but she needs to be medicated. So I'm trying to figure out where can I provide any kind of assistance on this without it becoming too legal. Because I have a feeling that the judge is they know who I am and who I work with, or how I work with her. And I have a feeling I'll be subpoenaed. But I want to know, what can I do or ask for from the judge to make sure that I do my due diligence for her.
Mm-hmm. I think I think you're on the right track as far as seeing about guardianship, but also, where is she? Does she want to go to jail? Does she understand the repercussions? And sometimes a really direct conversation about, listen, I want to help you not do this. And to do that, you need to start meds now. And you need to demonstrate to the judge that you're trying to do something different. And because that's oftentimes helping them see the path to avoid what they don't want, is really helpful. I don't know where you're at, but you could also reach out to the Department of Health and Welfare, to the what I am, the 18 to 11 to 12 specialist, and kind of problem solve with them too.
Okay. Yeah. Again, she doesn't remember the situations like they happen. She's in denial that any of the incidences have happened. Like, she spit on a kid at Walmart and hit the mom, doesn't remember. She says the female did that to her, that she was the one assaulted. So she's completely in denial and sees no issues with her her mental health. And so therefore that in lies the biggest obstacle I have been dealing with. And because of the court case, she cannot review the tape at this point. She has not sought out legal counsel either. And that is really disturbing for me because she's going to go in there. The judge is going to see the video. And I don't know with the escalation of her violent behavior, what's going to happen because I know she doesn't belong in prison. So that's, and I'm going to take it that the judge is going to use his own best judgment as well. But I'm kind of torn because, mental health is what I do. So I'm just very distraught and kind of running into a brick wall at this point.
Right, right. Well, and sometimes it's hard because we just have to let the process work itself out, because if she's not really been in front of the judge or whatever, and once they are in front of the judge, then the judge can determine that that person needs an evaluation, and then the process starts. Chances are you won't be subpoenaed if it goes to the 18 process. We don't see that. So yeah.
I appreciate your time. I know this took a little bit out of the training, but this is something it's very near and dear to my heart. Been working on for a hot minute, and we've made such good progress to see such a huge relapse. So I appreciate you answering my questions.
Sure. Good luck.
Somebody asked in the chat, what would a guardianship do to change the circumstance? And really, guardianship is generally the most helpful when somebody needs to be placed in like an assisted living facility or a skilled nursing facility. Their ability to take care of themselves has deteriorated to the point, but they're not willing to do that. Because a commitment, we can't force individuals to live certain places, but with the guardianship, that generally is the only way in which a family member can take guardianship and then sign the person into the care and services, where it sounds like if she's refusing, any sort of help or assistance or things like that, then, even if she's able to maybe maintain living independently, if she had personal care services or home health services or things like that, a guardian would be able to sign for those services, whether or not she wanted them.
Right. And I think that's the thing. It's like, if there's ongoing deterioration, that's probably where they're heading anyway. And the mental health system is not, and the criminal justice system is not the ones to be resolving this. It's getting her into the treatment that she needs. So I wanted to, because we're getting pretty close, I wanted to jump ahead to this on what the commitments don't do. So as we said, we cannot do guardianship. That is not what DHW does. We cannot make an individual participate in treatment unless they're in the hospital and they undergo a treatment override is granted, which is a formal process that the hospitals do. We cannot put somebody into substance abuse treatment. We cannot send them out of state for treatment. We cannot complete neurological and medical testing. A commitment, even a civil commitment, is for treatment of mental illness. It is not treatment for any other situation. We've had people who are under civil commitments in the community and need medical treatment, and we cannot grant that. We have no authority. They are only committed to the Department of Health and Welfare for mental illness treatment. And then we can't do competency restorations for non-mental health issues. So that's kind of where we're at. Yes, I agree. In the chat, something was said that we have difficulty finding placements for people who will take people with behavioral issues. Absolutely. The Department of Health and Welfare has the same challenge. We have people who are often waiting at one of the hospitals, waiting for placement, and oftentimes a story gets created about an individual, and I encourage people to really highlight what's improving and what's changing to help a place see that they are workable. So yeah, it's a definite challenge for all of us. Any other questions? Jessica, any closing comments?
No, not that I can think of. I definitely think in those hard to place situations, the more people, heads that we put together, you sometimes have to kind of lean on those relationships with the different facilities and really highlighting, like you said, that the improvements that are made, and just really kind of encouraging and keep approaching and reapproaching to see if they'll give them a chance. I mean, but I think the more heads that get put together, and sometimes it is looking outside of the area. Sometimes, a person's just burned too many bridges in their community, and the only option is finding a place that may be a little more willing to give them a try somewhere,
Right.
that they're not so well known.
Yeah. So there was a question in the question and answer, and it says, do you know if a federal judge is able to order commitment, or is it just the state side? So I've not ever heard of a federal judge doing a commitment, but if they commit them, if a federal judge commits them, then they're committing them under federal law, which I would really suspect if there is any. But a federal judge cannot commit under a state law. That's not the way it works.
Yeah, I'm not familiar with a federal. I mean, each state has their own individual laws, and so it has to be a district or magistrate state judge, because they're committed under the Idaho statutes.
Right. And Idaho statutes are only good in Idaho, right? So if we even have somebody who is committed under Idaho statutes and they abscond and go to Montana, there's not much we can do besides drop it, because we have no authority to go over and get them, because they're committed to Department of Health and Welfare, and our authority is pretty limited. So
and we run into that sometimes with the civil commitments. If a community emergency room is looking for placement, and sometimes you have staff changes and people aren't familiar, and they find placement for somebody down in Salt Lake City, but they're on a hold, that once that person gets to the state line, that hold doesn't matter anymore. We don't have authority outside of the state.
Okay, ladies, thank you so much, Jessica and Dia. What an informative presentation. I want to remind everybody to check your confirmation or reminder email for full CEU requirements. You will find your evaluation email will be in your inbox in about an hour, and you have to finish it within 48 hours. And you do have the option to redo. While you're in there doing the survey, you can redo it as many times as you want. And it does tell you where you're at. I will send an email possibly tomorrow with all the links from the session. I'm sure they'll be helpful. And you can direct questions to the EI email in the chat. I'm hoping one of my colleagues slaps it in there. And the slides and recording will be available on the website in a couple of days. I see in the chat, there's all kinds of thank yous. I know that people were very interested in this. I certainly was. Thank you once again, Jessica and Dia, and thank you all for attending. We appreciate it. Have a great rest of your day.
Thank you everyone for your attendance and your questions.
Great job, ladies.
Thanks, Mary.
You were right. We had plenty.
It went well. It went really
you.
well. Thank you. All
Thank
right.
you, Jessica, so much for helping and jumping in.
Well, thank you for jumping in at the last minute. I appreciate you more than you know.
My pleasure. Thanks all.
We'll see
I'll
you.
be in touch with you. Thanks
Okay.
again, everybody. Bye-bye.
Bye.